afternoon, everyone. This is Terry Likowski. I am the NIAAA's Government Affairs Representative in Washington, D.C. We really appreciate everyone taking the time to join us for this afternoon's webinar. I'm really excited to get going and talk in depth about how we can provide greater access for kids with disabilities and women and girls for our sports programs. A couple of housekeeping items before I turn it over to our esteemed speaker. Everyone should be participating for the webinar via their computer. If you're having any technical difficulties, in the top right-hand corner of your screen, you should see a green light. If your light isn't green, it's probably why you're having some problems. And you can contact webhelp@telespan.com for immediate assistance. Again, that's webhelp@telespan.com. At any point in time throughout the webinar, you can type your questions into the bottom left-hand screen of your computer. When we get to the Q&A portion of our discussion, we'll be pulling our questions directly from the chat room, so feel free to send these in as they come to mind. We'll try to get to as many questions as possible. This webinar is also going to be live recorded, so feel free to not worry about taking notes, because we'll have this up for you guys to access at a later point in time. So with all of our housekeeping items covered, one more thing is timing-wise, we're shooting for this to be about an hour-long webinar. We're going to have 20 minutes of initial presentation, kind of covering the disability and sport dear colleague letter, and then 20 minutes for Q&A specific to that. We'll have another portion of presentation with some updates around Title IX in sports, followed by another Q&A session for around 10 minutes. At this time, I'd like to turn the conversation over to the Acting Assistant Secretary, Seth Galanter, for the Office for Civil Rights. Seth has been a long champion and advocate for civil rights. Used to work at the Department of Justice before coming to OCR, and his team spearheaded the development of this Dear Colleague letter, so we really appreciate him taking the time to present to our membership. And Seth, on behalf of the 8,000 athletic administrators that the NIAAA represents, we just really want to appreciate and say thank you for your leadership in this effort, and let you know how committed we are as an organization to serving kids with disabilities in our school athletic programs. So thank you for taking the time to speak to our membership today, and we're eager to learn more about what you have to say.
Hi, Terry. Thank you, and thank you all for joining today's very, I hope, educational call, talking about the civil rights responsibilities that come with athletics. Let me start by just saying that the Secretary of Education, Arnie Duncan, and myself, but particularly Arnie from his sports background, recognize that sports can be invaluable, provide invaluable lessons in discipline, selflessness, passion, and courage. And we're hoping that the guidances that we talk about today are going to help you and help your schools ensure that students with disabilities, ensure that women, and ensure that racial minorities have an equal opportunity to benefit from the life lessons they can learn on the playing field or on the court. And the statutes that we enforce here at the Office for Civil Rights, here at the Department of Education, prohibit discrimination on the basis of race, sex, and disability. Today I'm going to focus on the sex and disability discrimination, primarily because the push for race integration was relatively straightforward in comparison. When you think about the movie 42 and Jackie Robinson's story, what you think about is, for race, the remedy for the unequal opportunity was the elimination of segregation. Now, for sex, in which Title IX regulated in 1972, the remedy for unequal opportunity for girls was the creation of separate teams. And we're going to talk a little bit about that at the end of the discussion. But here, and what we haven't talked about here at the Office for Civil Rights until we issued guidance this January, was what is the appropriate approach for kids with disabilities and athletics. And so what I'd like to do is go through a presentation that walks through the guidance we issued at the beginning of this year. And you should all be seeing a PowerPoint presentation right now. And I'm going to click through some of the initial slides to talk about extracurricular athletic activities. We issued this letter in January 2013, and hopefully you've seen it, and hopefully you've had a chance to read it. But since it's long, I'm going to give you some highlights today. What prompted this guidance? Well, in June 2010, the U.S. Government Accountability Office said that we had not clarified to schools and to people with disabilities what their rights and responsibilities were involving extracurricular athletics. Does it state new requirements? No. What this is doing is it's clarifying what the law has been since 1973 when this statute was first enacted. And this guidance, although it focuses on elementary and secondary schools, the principles that are articulated here, and which I'm going to go into, apply not just to elementary and secondary, but to all post-secondary schools as well. And it also applies to athletic associations. And I realize that many of you are, as athletic directors, work both with your school districts and with regional and conferences, as well as athletic associations. Essentially, everyone you work with is subject to these same rules, and you all need to be working together to create a system that works for you and complies with Section 504. So what is it that the 504 requires? 504 is, has always required that school districts provide students with disabilities what's called an equal opportunity to participate in extracurricular activities. So what we've done is created a gloss, an explanation of what an equal opportunity looks like for interscholastic sports. But I think it's important to make clear first what it doesn't mean, because a lot of the times people get too fixated on the extremes and don't really focus on what the law is actually focused on. First, equal opportunity does not mean, for example, that every student with a disability is guaranteed a spot on an athletic team for which all other students must try out. School districts may continue to set a required level of skill or ability for participation in a competitive program or activity. Also, school districts can adopt bona fide safety requirements needed to implement its extracurricular or program or activity. The school, when it's considering and relying on safety, must consider whether safe participation by any particular student with a disability can be assured through reasonable modification or the provision of aids and services. And I'm going to talk about those two last terms, reasonable modifications or provisions or aids or services, a little later. But the point is essentially we're not trying to change the nature of the competition, and we're not trying to imperil the safety of any student. What are we trying to do? Well, the first thing we're trying to do is what's quoted here in Principle 1, promote equal opportunity by assuring that school districts not act upon the basis of generalizations, assumptions, prejudices, or stereotypes about disabilities. This is, in fact, perhaps the easiest one to say, the lowest cost one, but the one that a lot of us have to focus a little more deeply on, making sure it doesn't happen. Teachers, administrators, coaches, and other students can't act upon generalizations or about reflex judgment about what students with certain type of disability are capable of doing. For example, one student with a certain type of disability may not be able to play a certain type of sport, but another student with the same disability may be able to play that sport. We need each student to be looked at as an individual. The second and related principle, which I mentioned earlier, is that school districts can still set required skill levels and safety standards. The OCR guidance is about expanding opportunities and inclusion. It's not about changing the nature of the athletic activity. That is, if the school has a selective sports program, a kid with a disability does not automatically get on the team or get to play just because they have some minimal skills. In those cases, school districts can continue to select the best players as they define it, as long as they aren't excluding kids because of their disabilities. So then what do we mean when we say look at the kid as an individual and look at the kid for his abilities and not his disabilities? We mean, first, that they have to make reasonable modifications to their program to allow for participation by students with disabilities. Now, what does that mean? Well, a modification is reasonable if it doesn't fundamentally alter the program or activity. That's nice, but if you ask me what does that mean in practice, the point is the school first has to figure out what the kid needs in order to see whether the kid can, even with the modification, participate in the activity. Now, the guidance goes into greater detail about this, but basically it's a case-by-case analysis where we look to see what is reasonable and what would make a fundamental change. So what's a fundamental alteration? A fundamental alteration, really you look at two things. Does it change the essential aspect of the game, or does it provide the student with an unfair advantage, or is it going to cause someone to get hurt? So the first one, if the essential aspect of the game of baseball is having, 4 bases, so to ask them to add a 5th base or to take away a base would constitute changing the essential aspect of the game, and a school doesn't have to do that. Alternatively, a change may have only a minimal impact on the game itself, but it might give a particular player with a disability an unfair advantage over others, and for that reason would not be required because it would fundamentally alter the game. In that case, though, you have to look to see not only whether that particular modification would constitute a fundamental alteration, but if there's some other modification that you could use instead that would permit the student's participation. Now, the fourth principle, and it's related to the third about reasonable modification, goes to the question about aids and services. Now, a school district must provide aids or services to students with disabilities in order to provide them with an equal opportunity. And the guidance talks about this to some extent, as these examples hint, assistance with insulin administration or sign language interpreter, things schools are already providing during the school day. One way that this intersects with what's called FAPE, a free appropriate public education, which is what a school district must provide during the school day. Now, these don't apply directly to after-school activities, but they're very helpful in figuring out what needs to be provided in order to provide the equal opportunity required for extracurricular activities. So one way to determine what a kid needs is to use the individualized education program that's designed by the IEP team, where the athletic person would need to also join to participate in explaining what is necessary for the kid to participate in the athletic program. But outside the FAPE process, a student with a disability must still have an opportunity for participation in the school district's extracurricular athletic activities. They have to examine whether the provision or an aid or service is necessary to provide the student with that opportunity. Now, although you can raise a fundamental alteration defense, we at OCR have found that those have rarely, if ever, prevailed in the context of extracurricular athletics. Whenever IDEA, the Individuals with Disabilities Education Act, requires a duty to provide aids and services, such as insulin administration, OCR is rarely going to find that the same needed aids or service for extracurricular athletics constitutes a fundamental alteration. So now let me turn to cost, because I think that's something that many people have raised as a concern about compliance with many civil rights laws. Now here, providing reasonable modification and aids and services shouldn't create new costs for school districts. And in the guidance itself, we give a number of examples that would be low or no, in fact no cost. Implementing a one-hand rather than two-hand touch in competitive swimming, using a visual cue such as a laser pointer in addition to a starter pistol at a track event, or implementing a modified coaching strategy. Now, none of these things would constitute a fundamental alteration, and none of them would cost any money. Now, let me just pause on the modified coaching strategy because some people may not be familiar with what I mean by that catchphrase. What we're suggesting is perhaps for a student with an intellectual disability who requires the use of a modified coaching strategy, it might be breaking down skills into smaller parts, working one-on-one, reinforcing acceptable behavior, using picture boards or other assistive devices, establishing eye contact while talking, or working in small groups or having athletes work in pairs. All those kinds of things, low cost, no cost, that would allow an individual with an intellectual disability to participate if they're otherwise qualified in the sporting activity. Now, if use of these coaching strategies alters some essential aspect of the sport or gives the student an unfair advantage, then it wouldn't be required. But school districts are already providing these kinds of equal opportunities to students at low or no cost. So now, what is it that, are there rules here? And the short answer is no. The rule is that it's an individualized inquiry. The needs of the students must be determined on an individual basis, and you need to look at your program and how you can include the student in your program with reasonable modifications, with aids and services, and without regard to stereotypes. Now, what happens if you've gone through this process, you've gone through the individualized inquiry, you made the reasonable modifications, or you've decided they're not workable, and still the kid with the disability doesn't have access to the benefits that athletics provide? When inclusion isn't possible, school districts are encouraged to create additional opportunities for those students with disabilities through separate teams. And what are we talking about here? We're talking about things like Special Olympics, unified sports. We're talking about adaptive or allied sports on which students with disabilities participate with students without disabilities. We're talking about creative ideas like developing district-wide or regional teams with students with disabilities as opposed to a school-based team, or mix male and female students with disabilities together to get a sufficient number for the team, for the sport that you're talking about. The Special Olympics is a great resource for implementing a fully inclusive sports participation path. Also, our Office of Special Education and Rehabilitative Services issued a guidance document that talked about the value, alternative ways to provide these services to kids with disabilities. What I'd like to do, I think, is stop there for a minute. Wait, let me see. And take some questions. But before I do, I'm going to, wonderful. Put these resources up about the Special Olympics, and then in a moment, about halfway through the questions, what I'll do is I'll post the contact information for OCR and for the guidance that I've been talking about. And while I do that, with Terry's help, I'm going to take your questions to try and talk more about the guidance. Okay. If you have a question for me or for Terry or for me, please chat by typing in the lower left-hand box on your screen, and we'll get to see that, and we'll be responding in real time. Until then, Terry, did you want to ask the first question to get things started? Perhaps not. But while we're waiting for the first question, let me tell you about what I was so pleased about when we issued the guidance in January 2013 of this year, was the amazing positive response we got from teachers, students, coaches, athletic associations, and the public at large. Everyone really recognized, I think, the values of athletics and the importance of bringing kids with disabilities into this. And also what was really heartening was all the work that was already being done and not really recognized at a national level for people including kids with disabilities in sports. We saw a lot of very good news stories about blind runners, about kids with disabilities as cheerleaders, about kids with disabilities in pole vaulting, swimming, and then it came right around the same time as the Paralympics. So we got a really good positive buzz going And we're very encouraged to see, as I got to speak with people and as people raised questions, the really positive ideas and creative ideas that were being shared about how to include all kids into interscholastic athletic opportunities. I have a first question, which I'm going to read out loud, and the question is, what accommodations should be made for a deaf offensive lineman? And here's where I have to start revealing that I'm not a football guy. But I can tell you that generally kids with hearing impairments are entitled to accommodations, and that both for wrestling and for other sports where there needs to be a lot of one-on-one coaching or continual coaching while the person's on the field, there have been opportunities, there have been many folks who have been able to coach kids who are deaf with sign language or with other code signals, and that accommodations have to be made sometimes. For example, I'm thinking of one case involving a wrestler where the coach was allowed to step outside the area normally reserved for coaches so that they could continue to provide coaching while the kid was in the wrestling match. And let me, I think we may be having a little technical problem with Terry. She may have something to supplement that one on. But I'm going to move on to the next question, which was, can we make a categorical determination based on those with wheelchairs that wheelchairs would be unsafe, change the game, or give the athlete an unfair advantage? That's a really good question. And I'm assuming this is probably in a track or field event, or I'm going to assume that for the purposes of my answer. Categorical determinations are among the toughest things to support in a disability context. I'm not saying they're impossible, but certainly to say that a wheelchair is unsafe or that a wheelchair is would change the game, well, let's start with unsafe. We have lots of different kinds of drivers in the world. We have lots of different kinds of passengers. It's hard to make categorical determinations that cars are unsafe just because some people get into accidents. You would have to look at the ability of that particular kid to control their wheelchair. I know that there have been some instances where coaches have allowed their wheelchair kids to practice with the rest of the team, and there haven't been problems, and they've been able to use that evidence to show the athletic association that there isn't a safety issue. Conversely, if there's a particular kid who can't brake properly or is having problems staying in their lane, and even when you put them in the outside lane, they continue to have problems, of course, we're not going to, no one would require that that kid be allowed to put others at risk, just as if you had a kid without a wheelchair who was constantly drifting into other lanes, tripping other people, you would take action about that kid. But can you make categorical rules about safety? That's pretty hard. About whether it would change the nature of the game, yeah, that does feel like a much more categorical rule. Either it does or it doesn't. Obviously, if you're not playing competitively, then the nature of the game isn't competitive. But if you're playing a competitive game and you can show that kids in wheelchairs are just playing a different game, then yeah, you could exclude them. Now, whether that's true in many track and field events is something that's debated. Obviously, you may have a different result for for not pole vaulters. What's the thing we throw the thing really hard? Javelin, thank you. Or than you would for track and field, or, for example, pole vaulting. But in any event, it is something that you would need to look at and not just react based on instinct. One of the only Supreme Court cases about sports and disability involved a disabled golfer, Casey Martin, and the question of whether he would be permitted to ride a cart from hole to hole rather than walk through as all. Did not change the nature of the game to allow him to ride because walking wasn't the essence of golf. Many people disagree with that, but there is an opportunity to look intensely at what is the nature of the game and figure out what it is that makes it the game that it is. Similarly with the unfair advantage, We don't want, obviously motorized wheelchairs are going to give many kids advantage. So that's obviously excluded. But when we're talking about, people who have prosthetic limbs, we do have to be careful that we're allowing them to participate when it's appropriate, but we're not allowing them to participate when it would give them an unfair advantage over the other competitors. And you may say to me, well, how am I supposed to determine that? I have to say this is one of those things, like the question about the offensive linebacker, where it's your expertise as athletic directors, as coaches, about how kids react, the natural spectrum of ability within your kids, that's going to really matter most. You should definitely check, if you can, with your Interscholastic Athletic Association, with your 504 coordinator, because they have I know I've spoken with the National High School Federation and with the NIAA, and they're both very eager to provide the kind of technical assistance and work closely with us here at the Office for Civil Rights to make sure that the right information is getting out to the public. But the next question, there's two questions that both touch on transportation. Let me read them out loud as I try and formulate answers. Should it be necessary for reasonable accommodations to include the student being transported to the facility outside the home school district? Who is responsible for transporting the student? And someone else asked, just moments later, what if we only have one athlete with a disability and there's no other local activities? Does the school need to pay for transportation outside that area for the athlete? This goes to something that we touched on very briefly in the guidance, and which is an unexplored area, I have to say. But the guidance says that once you start providing athletic activities for kids with disabilities, you have to provide substantially equal resources. And we don't really go into detail about what that means. But certainly in one example that's identified here, if you transport lots of kids outside the school district for various athletic events, and you've helped get a kid with a disability into an athletic event, then yeah, you're going to have to pay for those transportation costs. That's my opinion now. I haven't thought deeply about it, but I just need to flag for you that you have to give them the same resources, not on a per dollar basis. So if you're transporting kids for athletic events, then yeah, you got to transport kids with a disability for the athletic event, especially if you're unable to include them in your event. Now, looking at the transport, who's responsible for transporting kids? Now the who has the responsibility? That, federal government doesn't really reach that far into school districts, believe it or not. If you already have a system for transporting kids to athletic events, that's the same kind of system you need to use for your kids with disabilities. At least that would be the starting rule. Now you may come up with exceptions. There may be exceptions. As I said before, there is a fundamental alteration and cost concerns can weigh in. But when we look at those things, we're really looking to see, are you giving the kid with the disability a fair shake, particularly when you're not able to fit them into your regular program? The next question I got was, can we get a copy of these slides? Absolutely. I will work with Terry and the NIAA to make sure that they are either posted on the NIAA website or circulated to those of you who are participating in this call. I'd also remind you what Terry said, which is that we're live. This is being taped for the future as well, and so you'll be able to access this resource, including the slides, at your convenience. I'm looking at the time. We have a time for a couple more questions. So if you have them, otherwise in a couple minutes I'm going to turn to the Title IX issues, and then we'll take questions again at the end. As our office, my office, the Office for Civil Rights, become aware of any current programs utilized by states that are not considered reasonable? That's a tough question to answer, but the short answer is no. We have several complaints pending with OCR where students or advocates have filed complaints, and anyone can file a complaint. And let me shift back to the other slide now. That claiming that their rights have been violated under 504, and we have a process for investigating those. To my knowledge, none have reached a conclusion that there's been a violation of the civil rights laws, but there are some that are still in process where the school district or the athletic association has changed their process in light of the OCR investigation. But I can't come right now and identify any that were found to be in violation of the process. I got a couple of questions. I guess you can all see these questions with me, but just for posterity in the videotape, I got a question about who should be involved in making these determinations and what should people be doing to look at their policies and practices. We don't really require any particular process be used or any particular participants be involved. If we were going to be doing an investigation, that is, no one complained, we would look at process to see whether the athletic director had made a reasonable inquiry. Didn't just assume that all kids with learning disabilities were bad and stressed, but talk to the kids' teachers, talk to the kids' parents, talk to the psychologist, and if necessary, reach out to the 504 coordinator or someone else to get some expert advice. But ultimately, we're not trying to federalize decisions about who gets to play on the team. What we're trying to do is get the basic notion of inclusion built into the process that you're already using. And I think that Terry raises a good question about what people can do to look at their policies right now to provide for these individual assessments. Now, all schools right now use the IEP process, the Individualized Education Program process, for some kids with disabilities, either IDEA kids or 504 kids. It's possible that that's a good forum because it has the parents, the kids, the homeroom teacher, or the regular ed teacher, any specialized teachers that kid needs for any questions to go to that person. On the other hand, as I said, a more informal process within the athletic department may be as appropriate. It really depends, I guess, on what the kind of question is. If it's a question about what this kid needs in terms of altering or modifying the rules of the game, that may be one thing. If it's whether the kid, how to get the kid insulin administration or how to get the kid a sign language interpreter, obviously that's something that's much better done through the IEP team, which has access to the school resources and to the contracts necessary for that kind of work. And the last question I'm going to take on this is someone who wants to follow up on an earlier question about if accommodations are being made by other districts that have a large number of students with needs, and our district only has one student, would we be obligated to pay for that student to go to the other district to participate? Wow, that's a hard question and a new one for me. So I just want to first flag by saying that that I haven't encountered that question before, which suggests it may not be coming up a lot yet. Certainly, that intersects with a lot of different issues. And first, let me say that the presumption of IDEA and the presumption of 504 is that kids with disabilities are going to be able to learn in their neighborhood school or in whatever school they would go to if they weren't a kid with a disability. So that's slightly in tension with the notion of transporting the kid to another school to receive certain activities. On the other hand, we have recognized in the past that sometimes you can look at cluster some services for kids with disabilities. That is, not every school has to have specialized autism teachers if you want to bring the autism kids to one place and it's not too burdensome on them. Whether these rules would apply to extracurricular activities is a tough one that I don't think we've really grappled with. And if you need more information, the thing I would suggest is that you reach out to OCR at ocr@ed.gov, or you look at our website, www.ed.gov/OCR, and find the regional contact. OCR has 12 regional offices that covers the nation, and someone there can start walking you through the analysis, see what is required in that particular situation. But I would just start as I ended, or I would end as I started, by saying that the value we have is really including the kids to the extent we can in their existing programs with their existing community. So let me, I've wrapped up this section, but I need to change the settings so you can hear Terry better before we jump into the Title IX area. So if everyone could just bear with me for 1 second.
Thanks, Seth. We really appreciate your feedback on the guidelines. I think this is a really helpful starting point for us to start thinking about what we can be implementing at a local level.
Terry, could you repeat what you just said?
I said thank you very much for taking the time to walk through with us the framework for the guidelines. I think this is helpful to start thinking about what type of policies and procedures our athletic administrators can be changing at a local level, and I'm sure some more questions will be arising as we get into the Title IX elements, but I think now would be a good time to talk about the Title IX piece, and then we can open up the Q&A that follows that to both, again, talking about the disability guidelines as well as some Title IX questions that anyone might have.
That sounds great, Terry, and it's wonderful to hear your voice. I'm looking for my Title IX page here. Hold on 1 second, I apologize.
While you're doing that, Seth, just to chime in on your response to the last question, we just actually left a working group of disability sports organizations who are kind of working on some practical strategies to hopefully deploy to athletic administrators, and one of the things we were grappling with is what to do in terms of accommodation of kids who have lower numbers when we're talking about adapted programs. And so I know that there are a lot of best practices out there in dealing with these co-op teams, where we see teams working across different districts as well as within different community areas. So Georgia is one state that has done this very effectively. So if any of you have further questions about that, through the NIAAA, we can certainly provide you with some local resources and disability sports providers who have done this as well.
Thank you, Terry. I think that's a really excellent point, and one I want to reinforce is that a lot of these answers are going to come, as the President has been saying, from the middle out, from innovative programs, from the Ethics Association, from the conferences, from the states. So we're glad to hear that there are national organizations like the NIAAA that are working to collect and disseminate those kind of practices, and also organizations like Terry's as well. I'm ready to talk about Title IX for just a few minutes and then turn back to the questions to wrap up. So I think Title IX has a slightly different history, as I mentioned before. When you mention Title IX to people, to the general public, girls' sports teams is really the first thing people think of. And that's for a good reason. Obviously, Title IX has greatly expanded athletic opportunities for women and girls, as well as its effect on the remainder of education. Title IX success, though, is really only partly created here at the federal level. In fact, it's your work as athletic directors, as school administrators, in institutions across the country that truly helps make Title IX a reality for students. Now, just a little piece of history, despite the broad scope of Title IX, athletics has been the area of most interest and focus and attention. In 1971, when Representative Patsy Mink was in Congress arguing the merits of Title IX, male high school athletes outnumbered female high school athletes roughly 12-1. Prejudice about the allegedly delicate disposition of women and their unwillingness to be competitive and to compete in sports pervaded athletic departments, certainly at the higher education level. With the passage of Title IX, we began to see a dramatic change in those statistics. For women's participation at the high school level, the increase has been more than tenfold. And it's brought about the same benefits for women that it has always provided to men. It increased self-esteem, it reduced drug use, it lessened dropout rates. Now, notwithstanding all these benefits, and notwithstanding the immense progress that's been made, there's still work to be done, battling the stereotypes and misconceptions about women and girls sports. And one of them is the misconception that Title IX has led to a decrease in the athletic opportunities for men. First of all, from a numerical perspective, there are more athletic opportunities for men today than there were 41 years ago when Title IX started. Again, focusing on high school athletics, the number of male athletes since 1971 has increased from 3.5 million to more than 4.4 million. And in fact, while women have made remarkable strides numerically, men's participation continues to exceed women, both in raw numbers and in proportion to enrollment. These numbers suggest that we have more work to do in ensuring that women's participation in athletics continues to grow until it meets their level of interest and ability. And we at OCR are committed to working with you on that goal without sacrificing men's athletic participation. And we have real evidence in our experience that it's possible. For example, in 2000, OCR initiated an investigation of Tacoma, Washington public schools. At that time, the district's enrollment was about 50-50, 51% male, but athletic participation favored boys 57 to 43. Now, that may not sound like a huge difference, but it meant that boys had over 400 more athletic opportunities than girls in that district. As a result of our investigation, the district agreed to take steps to accommodate the interests of both sexes. The district added several new sports teams for girls, developed athletic outreach activities in the district's middle schools, added new coaching positions, and created an athletics improvement committee. Now, the athletic participation of girls in the district didn't happen overnight, but it rose steadily, finally in 2009 reaching 49% that school year. Through a decade of dedication to equality in athletics, the district reached substantial proportionality, and it did it without dropping a single team. Now, certainly, it is time to reflect on this case and other cases that OCR has done in which Title IX has overcome the problems that affect discrimination in schools. But we have to also acknowledge that there's work to be done. And in addition to just looking at the numbers, we also have to look at whether the opportunities being provided are equal. And let me give you a higher education example about this. We investigated Ball State University. On almost every level, the female athletes receive fewer benefits than their male athletes. The equipment used by the women's team was inadequate or unsuitable. They were less likely to receive hotel accommodations for road games, and when they did, the rooms were overcrowded. They had inadequate locker room facilities, and women often had to change in sheds or cars. The women's team didn't receive pre-game meals, which the male athletes did. Recruitment for women's teams was less extensive. Women were receiving medical and training services from less experienced staff. And at least 3 of the coaches of the women's team had been fired, and a 4th had quit after OCR initiated the investigation. So after that, we entered into an agreement with the university requiring the university to correct all these inequalities. And they were also required to investigate all the coaching changes that occurred to assure that no one was being retaliated against for avoiding Title IX. OCR's enforcement efforts ensured that the women of Ball State moved literally and figuratively from sheds to locker room, and that they were no longer treated like second-class citizens. Now, we know resources are tight, and we know every institution is different and faces its own challenges. And we want schools to have many non-discriminatory tools as possible to reach and maintain compliance with Title IX. And this is the law part of my talk, which is actually pretty short on Title IX. our guidance has always offered schools 3 ways to show they're effectively accommodating women's interests. There are 3 that an institution is compliant if it meets any prong of the 3-prong test. Now, the first prong, which is probably the most widely known one, is that the number of male and female athletes is substantially proportionate to their respective enrollment. But that's not the only way schools and school districts can establish compliance. The second opportunity is that the institution has a history and continuing practice of expanding participation opportunities responsive to the developing interests and abilities of the underrepresented sex. Now that one, was very important in the 1970s when this program was starting and women's programs were just growing. It's a lot less important these days where schools have had 40 years to develop the history of continuing practice of expanding. And the third prong is that the institution is fully and effectively accommodating the interests of the underrepresented sex. And let me just talk about that last one for a second because it's often misunderstood, especially in light of the back and forth guidances that were issued during the Bush and Obama administration. What we're saying in that last one is show us that the reason that you are meeting all the needs of women, interests and abilities of girls. And that it's not enough just to wait and sit and say, if they want a team, they'll come to us and we'll give them one if we can afford it. You have to do proactive work to get a sense of what the interests and abilities of the people the girls in your community are. That requires some legwork. You're going to be looking to see at local clubs, your club, athletic club. But you're also going to be looking at local intramural activities that are separate from the school. You are going to be doing surveys, but simply surveying and then looking at the responses isn't enough because some girls aren't going to respond, not because they're interested, but because for the whole host of reasons people don't respond to surveys, including that they don't think it's realistic that they're going to get what they ask for. But of course, you also need to be open to hearing from women or from women's parents about what kind of teams they would like to see and would be interested in participating. So it is not the easiest of the prongs to meet, but it is the one that goes to the core of what we're seeking here, which is making sure that any student, male or female, has the same opportunity to participate in the sports of their choice. So we here at OCR have been working to do enforcement. That's one of the ways we achieve enforcement is by investigating complaints that are brought to our attention or initiating proactive compliance reviews based on a whole host of factors that we look at about where there might be problems. We've initiated about 16 of those over this administration involving athletics at both the higher ed and high school level. And we receive hundreds of complaints about athletics every year. Some of them don't get investigated because they don't provide enough information, but even of those, many go to investigation and do find problems. So we are also providing technical assistance like this, like our guidances, to help administrators and athletic directors understand what their responsibilities are so that they can work together with their associations, with the student bodies to achieve compliance. And that's partly, and in fact exclusively, why I'm here today is to answer questions and to encourage you to work with us and to work with organizations and work with your associations to make sure that you're proactively looking at our women, our girls, our kids with disabilities, is everyone being included, are all the interests being met, and if not, why not, and what can we do to make it right? So I think with that, I'd like to pass it back if Terry's still on the line, or to address any new questions about either Title IX or to go back to 504 to address any further questions that people had about 504.
Thank you, Seth. This is Terry. I have 2 questions for you actually that are, I think, common issues that we see a lot of our athletic administrators struggling with in the Title IX context that I wanted to pose your way. The first has to do with the issue of booster club money. And I know that it's something that our administrators struggle with at the local level regularly. You know, some schools have school-wide booster clubs, which they're able to exercise more control over. Some have sports-specific booster clubs. But could you kind of walk us through how that factors into the Title IX analysis if we're, you know, faced with a booster club that's buying new warm-ups for the football team or wants to renovate the baseball field? You know, how does that fit within the framework?
Absolutely, and thank you for that question. When I'm looking to my side here, I have my team of experts over here that are helping me make me look smart, and I'll come at the end of this call. But I would say that in that context, as in many contexts when you're dealing with Title IX, you have to remember that the whole notion of separate teams is itself an exception to the general rule that men and women should not be treated differently at all. And so when people intentionally create separate teams for men and women, we have very strict rules that we have to apply to make sure that there's true equality among them. And that means that we're looking here at the bottom line for the most part. We aren't interested whether someone, you know, left a trust for someone, whether there was a special lump sum of money that came back. The end result is how much are you going to be spending this year on girls and how much are you going to be spending this year on boys, and, you know, based on the requirements of the team, et cetera, et cetera. But the origins of the money really aren't relevant to that analysis. Yeah.
Yeah, you don't necessarily have to spend more on boys or girls.
Right, but the corollary to that, which is what Amanda was telling me offline, is that we're also not looking for dollar-for-dollar comparability here. It's more about outputs than inputs. We're looking about the benefits that are received by each team rather than the amount of money spent on each team. So that's yes. So I guess the thing is we don't care where the money comes from, and we don't care exactly about how the money is spent, as long as the benefits received by the boys teams and the girls teams are equal. And Terry, did that answer?
Yeah, so in the example of, you know, we have a booster club who's going to donate and build a new baseball facility, what you're basically saying is it doesn't matter if the school paid for it or the booster did, if that baseball facility creates a disparity in the treatment, then that would be a Title IX violation from your perspective.
I would say that on those facts alone, without any other information, yeah, that would raise serious concerns. Now, of course, if that baseball stadium can also be used for softball and there's a women's softball team, then it doesn't raise any concern. So it's going to be fact intensive, but yeah, the fact that it's given by a donor rather than by the school district isn't going to change the same analysis as if the school district itself bought the baseball stadium.
Great.
You said, Terry, that I think you had a second question?
Yeah, the second question I actually see another person raised the same issue is that there's been a lot of, I think, confusion nationally about the role of cheerleading and competitive cheerleading. And there was a recent case at Quinnipiac that I believe the Office of Civil Rights kind of weighed in on that was relevant to the collegiate space, and is wondering if you could clarify the role of cheerleading in counting or not counting for the Title IX analysis.
Absolutely. And let me start by maybe disabusing folks of another common misconception, and then talking about what it is we're really doing here. OCR doesn't certify a sport at a national level, at a regional level, at an association level, even at a district level. What we do is when we go in to a particular community looking to see whether they're complying with Title IX, and the community says we're invoking the substantial proportionality requirement, that is, men and women are participating in sports teams in about equal numbers, then we have to ask the question, well, what's a sports team? And that's when we get into the question is, in that community, for that school or school district, is what's going to count as a participant for women and a participant for men. And there, we've issued rather extensive guidance in 2008 that talks about the factors. It's not enough that it's a sport. It's not enough that it's athletic. And there's, as I said, there's a lot of factors, but one of the keys is most of what we consider sports in high school and in college are competitive affairs where you compete against equals or near equals. That is, a varsity team doesn't compete against a club. And usually, sometimes, someone wins, someone loses. There's some kind of hierarchy which leads to some kind of tournament. That's not every sport, but it's a lot of sports. And so we're going to look at what boys teams look like. How often do they play? Who do they compete against? And how does it end? Is there a state championship? Is there a regional championship? Is it just a local championship? And we're going to look at those same criteria in determining whether the athletic events that girls are participating in should count as sport and as Title IX sport for purposes of our counting for that prong of the test. And so far, certainly as Terry said in the Quinnipiac case, we looked at the facts after the district court had made his findings and agreed that based on his findings that at the higher ed level that the competitive cheer there wasn't enough of the kind of structured competition to make it equivalent to other sports that the universities were providing both men and women. At the high school level, too, I don't believe that we've identified a particular cheer program as competitive in that way. But I need to make clear that we're not saying that cheer isn't competitive. We're not saying cheer isn't a sport or not a Title IX sport. All we're saying is that it's going to require a look, if we're in there counting, about how it's structured and how it works in practice to provide the same competitive values that all the other teams offered by that school or school district or state are providing to kids who are participating in those programs. That's a really long answer, but I think it's really important to understand that it's very nuanced, and we aren't pre-clearing these things. People can't come to us and say, is our program a Title IX sports program? What we're asking you to do in making the assessment at prong one about whether you're providing substantially proportionate participation to men and women, to think about whether a cheer program would meet the standard that I just articulated, and which is really laid out pretty clearly in our 2008 guidance. And so let me just to close this one, and then Terry, if you have a follow-up question. I'm not saying, I want to make clear that, we're not saying it's not athletics. We're not saying that gymnastics aren't a sport. It's really the structure of the way the competition is structured that is one of the key areas that has, in the past, especially I think in the Quinnipiac case, which Terry mentioned, was found lacking. Now there's 13 factors that we look at, factors and sub-factors, but in many of these cases, it's the competition factor that seems to be the most important. Terry, did you have anything you wanted to add or follow up on?
No, I think you covered that one pretty nicely, Seth. I think there's another question.
I know we're running out of time, but before I wrap up, I do see there's one more question, which I think also touches on another misconception, so I'll just touch on it briefly, and then if there are no more questions, I'll just wrap up. Someone asked whether parochial or charter schools are held to the same accountability standards as public schools. The answer, let me split them out. The answer for charter schools is absolutely yes. Charter schools are public schools. They are held to the same standards as all public schools, period. Private parochial schools are different. The Department of Ed, 504 obligations are tied to the receipt of federal funds from the Department of Ed or some other department. The Department of Ed doesn't give money to very many K-12 parochial schools. When we give money to a parochial school, they are absolutely subject to the same non-discrimination requirement of 504. It's a little tweaked. They don't have to do everything that a public school does, but it really is pretty much theoretical because we fund so few. I would say maybe a dozen in the entire country. And remember, there's 100,000 public schools in the entire country. But parochial schools can be a useful ally. They are often trying to, I know, participate in competitive activities with public schools. And in those situations where you don't have sufficient numbers to have, when you can't include kids with disabilities in your mainstream sports, and you are looking at adaptive or unified sports, they are another source to look for kids to build up your team. But their obligations under 504 are limited because, as I said, most of them don't take Department of Education money. But charter schools, since I don't see any more questions, I would like to thank Terry, and I'd love to thank the NIAA. Once again, part of our goal here obviously is to enforce civil rights when we get complaints, but a big part of our role to ensure compliance is talking to the people who are making the decisions and who are administering the program and telling them what they need to do. My predecessor, Ruslan Ali, who used to be Assistant Secretary for Education, or for Civil Rights, used to say that no one comes to school in the morning saying, I want to violate a kid's civil rights. And we are committed to that premise and want you to know what you need to do and are available for technical assistance on through our regional offices, through our emails, through our website, and through working with advocacy organizations and with the Athletic Association to try and tell you what we are concerned about, what we think violates the law, and what we think is safe ground. And I appreciate the opportunity to speak with you for an hour here to talk about some of those issues.
Well, Seth, thank you very much for taking the time to present to us. We know how busy your schedule is, and really appreciate you taking the time to make this more accessible. I also want to thank everyone for participating. I know that this is a busy time of year with everyone getting ready to go back to school, so thank you for your commitment to these issues. And Seth, I just want to reiterate to you that the NIAAA has a long history and very strong commitment to providing opportunities for all of our students, and in fact have several certification courses that do a very comprehensive job of explaining, the rights of students with disabilities and Title IX for our athletic administrators, which we very much draw upon the resources of your office. So we're hoping to spread the gospel and continue to educate our membership about their civil rights and how to implement these in the school setting. So again, thank you for everyone for participating. This will be made available through the NIAAA. This was live recorded, so if there's any follow-up information you require, we can make sure to get that to you as well.
Absolutely.
This will conclude our call. Hope everyone has a wonderful rest of the day. Thank you again for your time.